Hi, and welcome to the Law Simplified. I'm Shaveen Bandardanayaka. A common misconception among many students all over the world, those who have approached me on this YouTube channel, as well as some fast track and masterclass students as well, is that there is one foolproof method of studying the law. The reality is far from it. This video is intended to illustrate a few techniques that are commonly used by students around the world to look at the pros and cons of each method, and then to recommend what technique might be best for you as a student that's just coming into the study of law, or someone who is in the progression of it, or perhaps even at the latter end or the later stages of your academic career. Now, by and large, if you take the overall function and the method of study, you can break it down into two main types. On the one hand, you have what I like to consider as the textbook method, and on the other hand, you have what I like to refer to as the podcast method. So let's look at each one in turn and consider what's best, what we can take out of it, and what's not so good, what we can leave out, so to speak. The textbook method is essentially what the name itself suggests. It's when students believe that you need to amass a great breadth of knowledge through the written material that you can get a hold of. For example, the subject guides that a particular university might provide, the textbooks associated with that particular subject, journals and articles, any written material relevant to the study of that particular topic specifically or the subject in general. Now, by and large, I've mentioned on a number of occasions on this very channel itself that reading is one of the fundamental components, not just of the study of law, not just of your academics, but of your career as well. Law is the type of subject area that what you do in your academics is not wholly different from what you would do in your career. In fact, it's a progression of it, I would argue. But having said that, many students believe that the key to success in law is reading, and only reading. On the one hand, this is necessary, and that is the plus or the pro of it. The more you read, the more you are able to articulate or understand the same topic perhaps from different perspectives. For instance, if you take a module such as criminal law and you take a topic like homicide, you might want to first have a basic understanding with the subject guide that is provided or the course outline that's provided by your university. Once that is done, you might want to flesh it out by going into the required or the essential reading indicated by the university, and then looking at the very specifics of the definitions, for example, of murder or voluntary and involuntary manslaughter. Once you've done that, you can go deeper, so to speak, into the rabbit hole by looking at the different common law precedent cases that have been mentioned, like Maloney, like Saunders, Vickers, and so on, and then go into depth on the judgments, the ratio, and so on. Afterwards, if you feel like you have the time and the patience, you might even want to seek out and use online libraries like LexisNexis or Westlaw and find journal entries or articles where academics have debated on the merits and the demerits of the different cases that you've just looked at, or maybe the law at large, even going as far as to considering opinions placed by the law commissions, for instance, in different years. Now, this is quite a lot for one specific topic, in this case an offense at that, in a larger module that would generally encompass a year. But this is the textbook method. Now, for many students, this would be the ideal scenario. They feel that when you study the law, this is what it involves, and you need to get as much reading done as possible. This is good by and large, but The demerit of this is if you are not the type of individual that is comfortable in gaining a lot of knowledge at once, and you have the tendency to feel that memory is an issue for you, and you associate law and the study of it in the textbook method as being associated with memory, then this becomes overwhelming quite quickly, and you might burn out in the long run. Once you start seeing the topic at large and the depth to which you can go in preparing for it, the goal of amassing knowledge gets sort of swept away, so to speak, by the fact that there is so much to go through, and this is only one of perhaps 10 or 12 topics that you have to go through. The other method is the podcast method. So the podcast method, as I have understood it, is much more beneficial to younger learners, those who are more privy to the content or the vastness of the content that is available online and in more audiovisual forms. One good example of the podcast method or audiovisual content in the line of law is what you would find, for instance, as lessons on my channel or courses that are available on my online law school. Similarly, due to the prevailing circumstances in the world, you would notice a lot of one-on-one online sessions happening and webinars happening from the perspective of institutes and universities. This technique of communicating audio-visually the same content that others might read in the textbook method have proved successful for some students. Now, granted, this too you could consider in the same level as the textbook method. You would begin by finding material and information in a very basic level to understand the outline of each individual topic that you have to study. And once that is done, you might go a bit more in depth and go into more detailed masterclass level lessons, which are more broader, have more discussions, and so on. Whichever component that you are studying through the audiovisual method, the process is almost identical to the textbook method. It's just that the delivery is slightly different. For some, the aspect of reading is somewhat of a letdown in terms of understanding and discussing with someone else. This is something that is provided for and substantiated in the podcast method, because by and large, it not only involves the actual material and the content being provided in a one-sided manner, but it's also included or it's also supplemented with discussions that sort of debate and critique what you are learning as you go along. Now, whichever method that you are comfortable with, and many students tend to gravitate towards one versus the other, the goal, and this might seem quite anticlimactic on my part, is actually to take bits and pieces of both and make a custom method that suits your specific requirement. No two people are alike, and the way we approach the subject of law should not be identical to one another. For example, when it comes to the study of cases, you might be more comfortable with reading something and grasping the idea as opposed to hearing someone explain it to you. Conversely, if it relates to a principle of law, it might make better sense to critique and argue why the law is in that way in the podcast method rather than simply reading one perspective of it by an author. So the idea then is, how best do you apply the law that you're learning through the methods that you're learning it? For example, I come from a computing and a software engineering background. And as part of our study, we use a technique called flowcharts. These flowcharts are very logical set diagrams that help us determine the processes of a particular system that we're developing, an application, so to speak. When I started studying law, in order to make sense of the vast array of content that is available, from the writing or the lectures or whatever it might be, to put everything in context, I found it easier to develop a technique similar to flowcharts And that is what you see scattered across this particular channel as well as my courses as the spider graphs. Now, the spider graphs were never the starting point. In fact, there were several sets of material that I studied as well as converted into notes, slowly and steadily making it smaller and smaller until it was compressed into a summarized format, which are the spider graphs that you see. There are several other videos on this particular channel where I detail out how the spider graphs were developed, however. Make sure you check those out in the links in the description below or the playlists that are available. But the point that I'm trying to drive across is the fact that it is not necessarily the method, whether it be the textbook or the podcast, that is important or that's critical. Rather, how you apply those into molding it, rather, into a technique that is worthwhile and that's fruitful for you. How we make it productive is what's going to make the study of law worthwhile and comprehensive, and how you will see it benefiting you not just in your academics but in your profession or your career as well. I've tried to illustrate this by virtue of the comprehensive fast track and masterclass courses that I've developed and are available now on my online law school platform, which you can access through the links in the description below or the link that will appear on screen now as well. These courses are a combination of textbook components as well as audiovisual content, which are supplemented with workshops as well as debates and discussions that I've had with students from all around the world who've achieved success in terms of their examinations or assignment submissions. This is a set of rich content which are available to you from anywhere in the world, for that matter, and in a subscription format as well. I'd like to consider that the online law school that I'm developing is essentially the Netflix of law. So do check it out. But having said that, until the next time that we meet, have fun, stay safe, and as always, obey the law.